Hello, everybody. Thank you so much for joining the Debt Hotline. My name is Hannah Locklear. I am with Team Solo, and I'm really excited to host tonight's live stream. Tonight, we have a really exciting topic, and it's a very common question that we receive at Solo. Since we are in the business of helping people respond to their lawsuits, since we are in the business of helping people respond to their debt lawsuits and file their answers with the courts, we do get the question, what happens after I file my answer? And so I wanted to kind of break down a few things that might happen once you've filed your answer in your court case. Before I get started, I did want to give a quick disclaimer and make sure everyone knows that I am not an attorney. Solo is not a law firm, so we do not represent people legally. Any information that we share in this podcast is simply educational, and we're trying to provide resources to people to help them, point them in the right direction, help them get on the right track to prepare for court or to know what to expect in a debt collection lawsuit process. So any information I share tonight is not legal advice. Please do not take it as legal advice. It does not apply specifically to your case, but hopefully it will help point you in the right direction, and hopefully I'll be able to share some resources that will also help you out. So thanks again, everyone, for joining. If you're watching live, please go ahead and start submitting your questions into the chat. We received a lot of questions beforehand today, so I'll do my best to respond to as many as possible. But just grateful for people submitting their questions, and we love to hear your stories and your situations, and Solo is rooting for you. We want to help out in any way that we can. So if you have other questions and about the lawsuit process, you can call us at the Debt Hotline. The number is 801-613-8181. And you can leave a voicemail. We will respond to these questions live each week. We hold multiple live streams where we talk about real debt issues from real people. So if you have questions, please call into the Debt Hotline and submit your questions. With that being said, I also, before we jump into the questions and the topic at hand, I did want to make a quick announcement about our giveaway that's happening right now. So we are currently running a giveaway for the month of July. It is called the In Debt Ended Stay giveaway. I'm going to go ahead and share my screen so everyone watching live can see it. So this is the In Debt Ended Stay giveaway. We're trying to celebrate financial freedom all month long, and to do so, we are giving one lucky winner $4,700 to help pay their debt. That's like $4,700 cash prize. The reason we chose that amount is because it's the average amount that people get sued for on the Solo platform. So the average amount that a Solo user gets sued for. And we wanted to help somebody pay off their debt and maybe resolve their lawsuit if they've been sued. So if you're watching, please go ahead and enter the giveaway. We want to pay it back and pay it forward. So it's a great way to maybe catch up on some of your debt and potentially even pay it all off. We're also giving away mini prizes each week. So the more you enter, you can enter once per day. And the more you enter, the bigger your chances of winning. We're giving $500 away each week leading up to the grand prize, which will be announced next week at the end of the month. So we will be announcing a mini prize winner tomorrow. So you still have time to enter and potentially win that mini prize or the grand prize, which again will be announced on it will be announced on August 1st after the month wraps up. So just wanted to make sure that was shared. And for those watching live again, I dropped a link to the giveaway right here in the chat. So you can click on that and go enter. All right. That being said, before we get started with the questions, I did want to explain a little bit about potential things that can happen once you file an answer to your lawsuit. So every case is different. I think that's one thing to note that's super important. Every state is different. The court procedure, the civil procedure is different in every single state. But on our website, solosuit.com, we have a blog that has resources for every single state and ways that you can prepare for court in your state if you've been sued. And we have state-specific rules. So we've done a lot of research to try to share information about, rules that are specific if you've been sued in California or if you've been sued in Texas or Florida, wherever it is. We have resources on our blog that you can read about to help you prepare for court, know what to expect in the process for your particular court involved. And, if you have further questions, you can always contact us at support@solosuit.com. That's our email address, and we're happy to help point you in the right direction. We also have trained AI on our website that you can interact with and ask questions that are specific to your case. The AI that we trained has been trained to pass the bar exam in the top 10%, so it knows its stuff. And yeah, we just want to make sure that we're providing the best resources out there for people who are dealing with this situation, because it's not a very fun situation to be in. It's stressful, and we get that. So that being said, I did want to take a few minutes to just break down a few options of what might happen if you have been sued and you've already filed your answer, and maybe what you can expect if you're in that position. So I'm going to go ahead and share another screen here. All right, so a couple things that could happen if you have been sued for debt. Um, Again, this is a very common question we receive at Solo. And so I just wanted to break down a few things that could potentially happen if you have already filed your answer, and what to expect if that's the position that you're in right now. So the first thing that might happen, and it may have already happened before you even filed your answer, is that a court hearing or trial will be scheduled. So depending on where you live, this may be like an automatic process that happens as soon as the lawsuit gets filed. So you may notice on your court documents that when you receive the summons and complaint, it says that there's a court date scheduled already, and it'll tell you like the court address, the time, the date, even the courtroom number. So that's something really important to pay attention to. Even filing an answer isn't going to stop that hearing necessarily from happening. And if you do have a hearing scheduled in your case, it's really important to show up. One thing you can do, though, is like file your answer, and you can even call the court clerk to see if there's been any changes to the case or the court hearing that is scheduled. It's really important to be proactive in your case, though, and keep up to date with all the statuses of your case and the court hearing scheduled. In some states, like for example, in California, their court system is pretty backed up at the moment. I think COVID really kind of contributed to that a few years ago. And they're still trying to catch up with scheduled hearings and whatnot. So if you've been sued in California, you might not have your hearing scheduled until months and months and months later. But that is not abnormal. Like, that is totally normal at this point to hear that you have a hearing all of a sudden scheduled maybe 8 months after you filed your answer. And that, like I said, that's super normal. So just be watching for any updates from the court. Again, you can be proactive. You can call the court clerk. If you don't know how to find their number, you can contact us at Solo, and we can point you in the right direction and get you their number. We have a database of thousands and thousands of courts across the United States that we can try to connect you with your court clerk if you have questions about your hearing and how to prepare, or where to go, how to, what you need to bring with you, all those things. So that's an important thing that might happen after you have filed your answer. Be sure to watch for updates on court hearings or trials. The second thing that could potentially happen is maybe after you have filed your answer, the plaintiff or the person that is suing you will respond. So they could respond by filing some sort of a motion. For example, if they think that your answer wasn't really valid or didn't have a lot of substance to it, they could potentially file what's called a motion to dismiss. Or they may file a motion for summary judgment, which basically just means like the person that I'm suing didn't really have that much evidence to prove that they aren't guilty or that they're not liable for what we're claiming that they owe. And so the judge should just rule in our favor and give us a summary judgment and give us what we want, basically. So the plaintiff may respond. And I did want to point out that for a lot of like law firms that are filing cases in bulk, they may have an automated process to where if they see that an answer gets filed, they automatically will file like motion for summary judgment in response to that, even without like necessarily reviewing all the details of the case. They have an automated system with lots of documents that get printed and mailed out every single day. And so just if you do see like a motion like that come through, you don't need to panic, because it doesn't necessarily mean that the judge has granted the judgment quite yet. But if there is any like hearing coming up and that motion has been filed, be sure that you attend, because what you say at that hearing could potentially help the judge make a decision and whether or not they should grant that motion. So that's another thing. The plaintiff may also respond by filing a motion to dismiss the case, which basically means they're saying, okay, we realize that we don't have the proper evidence or the enough proof to like substantiate our claims at this moment, so we're going to dismiss the case. They could dismiss it with or without prejudice. The difference between the two just means that you might see the lawsuit pop up again in the future. So that's something that we see happen quite a bit at Solo, actually. Like after people file an answer to their lawsuit, they may see that the plaintiff will respond with a motion to dismiss, and it just means that the case has been dismissed. That's like obviously best situation. If you know, if your case gets dismissed and it can't get brought up again in the future, obviously we would all love for that to happen. But in many cases, that's not going to happen, because you may not have like enough of a defense to prove that you aren't liable for the debt. So don't expect that to happen, but it's definitely an option and something we see happen quite regularly at Solo. Number 3, so after you filed your answer, the judge may immediately make a ruling based on your answer, or, you know, if they see any issues with your answer, or for whatever reason, if your answer didn't like comply with court rules, like maybe you didn't pay the filing fee, or maybe you didn't, there was some issue with not including all the proper forms that you need to include when filing your answer, the judge may make a ruling for like a default judgment in that case. If that does happen, it's not too late for you to, you know, respond and file what's called a motion to set aside judgment. This would help you kind of negate the judge's ruling for a motion or for a default judgment, and give you another chance to file your answer, make any corrections that you needed to make, pay the filing fee, whatever it is that you needed to do to make sure that your answer gets filed properly with the courts, and that the judge will actually like look it over and make sure that it's properly accepted by the court. So that's another thing that could happen. The judge could make a ruling, but usually rulings aren't going to happen right away until there's been some sort of a hearing or some sort of a response from the plaintiff. In some cases, the judge might even like dismiss the case based on how strong your answer was. For example, if you have like evidence and proof that the lawsuit is past the statute of limitations, maybe you're being sued for a really old debt that got kind of brought up by like a debt buyer or something. If that's the case, the judge might automatically rule that the case is dismissed and you won't have to worry about it. You know, that doesn't always happen. And it has to be very obvious and clear that the case is past the statute of limitations, and you should include that in your answer if that's what happened. So, and then lastly, one thing that we think is probably the ideal outcome in a debt lawsuit like this is if you've already filed your answer, you're actually at a point where you have a lot of leverage to potentially negotiate with the creditor or the debt collector or the debt buyer that is suing you, and try to settle the debt before you go to court. Because just like you, like attorneys, law firms, creditors, collectors, they don't really want to spend all their day in court. So just like you, they'd rather probably avoid going to court. So if you reach out to the law firm that's representing whoever is suing you, and you ask them about your options and try to negotiate with them to settle the debt before the court date, there's actually a really good chance after filing your answer that they'll work with you to try to find a solution. It's obviously easier said than done, but in my opinion, and I think, you know, in the opinion of Solo, in many cases, it's a really good time after you filed your answer to reach out and try to settle the debt before your court date, try to get everything squared away so that you don't have to have this legal battle in court. and deal with the stress of that. So these are some really common options of what might happen after you've filed your answer. And with that, I think I'll just go ahead and jump into some real questions from real people. We've got quite a few people watching right now, so I'm just going to go ahead and start responding to some of the questions in our live chat. Thanks again, everybody, for watching and for submitting your questions. And again, before I get into these questions, I did just want to remind you all that I am not a lawyer. I do have several years of experience dealing with debt lawsuits and helping with kind of pseudo paralegal work, if you will. But I am not a lawyer, so none of this is legal advice. This is just legal resources and information that can hopefully point you in the right direction. But thanks, everybody, for watching. And yeah, let's jump into some questions. So first question is from Roger Salvati. It says, I sent an answer to a lawsuit on May 27th. The attorney has not responded to the answer, and they have rejected 2 attempts to settle. Should I file a motion to dismiss at the 60-day mark? Okay, great question, Roger. This is not uncommon to see that you've filed your answer and that you've reached out and maybe tried to settle and they're not budging. I think that it's good to keep trying, keep communicating. I'm curious what your attempts to settle were like if you reached out to the law firm. Again, if you're trying to settle the debt before your court date, you're going to want to call the attorney directly to try to negotiate with them. And their information should be listed on all the court documents that were included when you got served. So it's best to reach out directly to the law firm and try to see what your options are. In many cases, it's good to offer kind of a little bit lower than the full amount that you could potentially pay off, and give yourself some room to negotiate. So if they rejected 2 attempts, I'm curious, was your first attempt a smaller amount than your second attempt? You have to be willing to negotiate too, potentially, to try to settle. But Roger, I think you're 100% on the right track, trying to negotiate and get things settled before you have to go to court. You were asking if you should file a motion to dismiss at the 60-day mark. So a motion to dismiss can be a powerful legal tool, especially if the attorney goes silent and they don't respond. The attorneys have to respond before deadlines as well. And so if they don't try to move forward with the legal proceedings, or if there is a court date and they don't show up, there's a chance that the court would rule in your favor in that case. So I don't know what state you're in, so I can't tell you, yes, you should file a motion to dismiss. But if your ultimate goal is to try to settle the debt, I would say it's best to keep reaching out to the law firm and just trying to negotiate. We have some resources, again, at solosuit.com that can give you some tips on how to negotiate. But in some cases, it's also better to offer getting on a payment plan with the law firm. Maybe you can afford $50 a month or whatever the amount is, to try to get on a monthly payment plan to pay off the debt. That might be a good option if they didn't accept your 2 attempts to settle already. You might try to see if they would accept some sort of a payment plan. Hopefully that was helpful, Roger. All right, let's see. Next question is from Moopy May. It says, I used Solo to respond. Or I use Solo Suit to respond. This process has been going on for about 2 months now. The last update was affidavit filed. What should I expect now, and should I attempt to settle? This is scary. So yeah, first of all, I do want to reiterate that this is not a fun experience to go through. It's stressful. It is scary. So definitely can empathize with you there. And but just know that you're not alone. Solo is here to help. And if there's anything that we can do to help, we would love to. You can use our tool called Solo Settle. And I think that could be maybe a good option to try to settle to the debt before any other legal proceedings happen or court hearings. Solo Settle is our settlement negotiation platform. Basically, it just digitalizes all of the settlement negotiation process. So if you want to try to send an offer to the law firm, but you don't really want to call them, or you don't want to wait till your court date to confront them in person, Solo Settle offers a really great option to move it online, send and receive offers from creditors and collectors. We've got more than 400 collectors that actively use our platform to negotiate with consumers, but it's always initiated by the consumer. So that's something that's really cool. You kind of get to take more control over the negotiation process. And our platform helps you send an offer to settle and make sure that you word it in a way that will protect your legal rights, that won't dig you in any deeper holes, anything like that. So, Mupi May, if you're watching still, I would definitely advise, using Solo Settle to try to negotiate if that is what you ultimately want to do. It said, what should I expect after an affidavit was filed? So I'm not sure what the affidavit is, but you definitely want to go take a look at it. You should be able to access that on your court's website, or even if you call your court clerk, you can ask for a copy of this affidavit to learn what it's all about. And you should also, so you said that this process has been going on for 2 months. Again, that is not uncommon. That happens a lot. So, the process could go on in some states. It goes on for more than a year. In California, that is not uncommon for that to happen. So you definitely want to probably read this affidavit to understand what's actually happening in your case. But if you do have the funds to try to offer a settlement, or if you have funds to set up a payment plan, a monthly payment plan, now that you've filed your answer, it could be a good opportunity for you to do that. Again, that's not legal advice. I don't want to say you should or shouldn't do that, but it may be a good opportunity for you at this point to reach out and negotiate. So again, Solo Settle is there for you. It's a great tool that will make the process a little bit less scary. Okay, next question is from Claudia. It says, can a debt collector sue you if your original creditor, Discover credit card, was merged and purchased by Capital One Bank? So as long as there is a trail of ownership of the debt, yes, a debt collector can still sue, even if the credit card was transferred to ownership from Discover to Capital One. As long as the debt collector has proof that they have the legal right to sue, yes, they can sue. If you think that for whatever reason they don't have that chain of ownership of the debt and proof of it, then you could definitely use that as an affirmative defense in your answer, or as maybe an argument in your case. But yes, short answer to your question, yes, they can sue you. They just need to have proof that they have the legal right to do so. And that will require documentation that comes from the original creditor, which in some cases debt collectors do not have, or debt buyers do not have. So again, that can be sometimes a good argument or defense in your case. All right, next question is from Her Bible Journey. It says, what if the statute of limitations is about to run out and the hearing isn't scheduled yet? So that's a good question. Long story short, as long as the lawsuit is filed before the statute of limitations runs out, it is still valid. So even if there's a hearing scheduled, but it happens after the statute of limitations expires, the case is still valid. It doesn't really affect the statute of limitations at this point when the hearing occurs. As long as the lawsuit was filed before, it will still be valid. All right, next question is from Damiana Flores. It says, for some reason it shows the date. Okay, let me start over on that one. I think there were 2 questions submitted. So Damiana Flores says, for some reason, my papers do not show a date or time, but it does show location of a court building. Does this mean that they want me to contact them before they take the court route? Okay, so in this particular case, it sounds like maybe the state that you live in, the court procedure is that the documents get filed. If you respond to the lawsuit, then the court will schedule a hearing. Again, some courts, they'll schedule a hearing as soon as the lawsuit gets filed. But in other states, depending on how the defendant responds, in this case, Damiana, you would be the defendant. So depending on how you respond, they may wait to schedule a hearing or a trial. So it sounds like, they're giving you the location of the court building and all the information about the court so that you know where the case is located. But and I could be wrong. I'm not saying that this is true particularly for your case, but it sounds to me like there isn't a court hearing scheduled quite yet. Damiana, if you want to know for certain, you could reach out to your court clerk and ask if there's anything scheduled for your case. And again, I always recommend being proactive in your case, trying to stay ahead of the game so that you know what to expect and you have time to prepare for court if you do have a hearing scheduled. Okay, I'm going to take a break from our live questions and go ahead and share some questions that were submitted beforehand via the Debt Hotline voicemail. So I'm going to go ahead and share my screen here. And for everyone watching live, please let me know if there are any audio or visual issues. But I'm going to go ahead and share some questions from people who called into the Debt Hotline and answer some of those.
Hi, I have a question. I filed a response to my answer. It's been about 45 days, and I've heard no response from the creditor. Just was curious what my next step should be. Thank you.
Okay, so great question. It sounds like you're just wondering what to do if you haven't heard back from your creditor after filing your answer, and it's been about 40 days, you said. 45 days, I think. So again, that is not uncommon. Many creditors will file lawsuits like in bulk, so they'll hire a law firm, and the law firm will use technology to like file a bunch of lawsuits all at the same time. And so they're trying their best to like keep up with all the lawsuits, but for cases that maybe aren't like super high dollar or that maybe there isn't like the strongest defense or maybe they don't have the strongest evidence that they should be owed the debt, whatever reason, there are all sorts of reasons why the creditor may take some time to respond. So if it's been 45 days and you're still waiting to hear back from the creditor or just figure out what the next steps are in your lawsuit, again, I think like a good place to start would be to call the court clerk and just ask, is there anything I need to know about my case? Like, is there any information or court hearing or trial scheduled? Like, what do I need to know and how can I prepare for the next step? Your court clerk might have some, like they're not a lawyer, so they're not going to give you legal advice either, but they might have some like helpful information about what to expect next for your particular court and state. That being said, we also have all sorts of blog articles at solosuit.com that might be able to help you know what the procedure would be in your particular state. In some states, there may be like a deadline for the creditor to take action after you have filed your answer. And if they don't take action, you know, there's a potential that you could file some sort of a motion into the case to try to get it thrown out or get the ball rolling again. But to answer your question, if it's been this long, there may be a reason why they've hesitated. And if you have the means and you want to try to settle, it might be a good time to reach out and try to settle the debt. Otherwise, you can just wait and see what happens. That's not too bad of a move either. But you know, in our experience at Solo, we from what we've seen and all the stories we've heard, settlement is usually like the best case scenario, because it's like it means that your debt is officially like resolved and you can move on with your life. You know, you won't have this looming court case over your head all the time. So that's another thing to think about. Hopefully that answer was helpful. All right, let's move on to another question.
Okay, so my question is, I'm currently being sued by Live Funding for a $5,000 credit card from Navy Federal. I was served at my home and I had a short period of time to answer the lawsuit. So I answered on the lawsuit stating I did not owe. I also went to mediation, did not settle to mediation, so now the case is going back to court. My question is, what kind of answer should I file to get the case dismissed, because it is a lawsuit that has passed the statute of limitations for the state of Georgia, which is 6 years. And I want to file an answer before I get a court date. Well, I want to file another answer before I get a court date. Is that possible or not? I fell behind on my credit card during COVID when I lost my job and was pretty much kind of living off of it. So it has been over 6 years since I've pretty much made the last payment on that credit card as well.
Okay, this is a very great question. So it sounds like you're being sued for $5,000 by LVNV Funding for an old credit card. LVNV Funding is a debt buyer. So LVNV Funding will purchase debts in bulk and then file lawsuits in bulk to try to collect as much debt as possible. And LVNV Funding will work with you to settle the debt if the case is valid and you actually do owe it. So that's something to think about. Like, if you are being sued by LVNV Funding, they will work with you. It might take several rounds of negotiating, but they will work with you. But it sounds like in your particular case, being sued for $5,000, you fell behind on payments during COVID and haven't made a payment since then. So it sounds like the statute of limitations has run out, and there is a chance that LVNV Funding has filed this lawsuit past the statute of limitations. If that is true and you didn't bring that up in your initial answer to the lawsuit, in some states, I don't know what the procedure is in Georgia. I'm not an attorney, and it may be a good idea for you to consult with an attorney at this stage if the case is going to court and you've already gone to mediation. It may be a good idea to talk to a lawyer and maybe just see what your options are. However, in some states, if you did not include that the statute of limitations was expired in your initial answer, which you usually need to do in your first answer, you could file what's called an amended answer. And it's basically going to be like very similar to your original answer, but with added detail. So again, if you did not bring this up as a defense in your original case or your original answer, that the case was past the statute of limitations, you could try to amend your original answer to bring that up as an affirmative defense. And if the judge can see clearly that the last payment was more than 6 years ago and whatever the statute of limitations is in Georgia, then there's a good chance that case could get dismissed. For debt buyers like LVNV Funding, it's not uncommon for cases to be filed that are past the statute of limitations, since they do have an automated process to file lawsuits in bulk. However, LVNV Funding is a debt buyer, but they're not just trying to go out and file lawsuits past the statute of limitations unknowingly. I think if they had known that the lawsuit was past the statute of limitations, they may not have bothered in the first place. But yes, if that is true in your case, then you definitely will want to bring it up in court. And there's a potential you can maybe do that with an amended answer. But yeah, just do what you can to bring proof in documentation, to bring like physical proof, documents that will prove that the last payment was made years ago, and now the lawsuit, like LVNV Funding doesn't actually have the legal means to file this lawsuit against you. All right, we've got one more voicemail question. One more question from someone who called into the Debt Hotline before.
Hello, my question is how to handle a letter of discovery that I've received. I'm being sued by Portfolio Associates for about $4,500, and I have filed a motion with the court to have it compelled to arbitration, and I'm still waiting to hear from the court. The only thing I've had with the court is they mandated a mediation meeting, which we didn't agree on as far as the amounts or anything. So I did file the answer, of course, and this is with Portfolio Associates, and I have other debts and collections, medical debts, and how did I fall behind? Fall behind because of medical debt. We have fully insured with high deductible, and we've had multiple children pregnancies, one was in NICU for 3 months. So you can imagine all the bills and everything. So anyways, thank you so much. Take care.
All right, so it sounds like you've been sued and the case has moved to discovery. So that's actually, I'm surprised I forgot to mention that that is actually a very common thing that can happen after filing an answer. The case may move to a process called discovery, which is basically where both parties in the case, both the defendant and the plaintiff, both the suer and the suee, if you will, where they can both submit documentation to the court that helps prove their side of the case. So if you have any sort of documentation in your case that proves that you shouldn't be held responsible for this lawsuit, this would be your opportunity to like submit it to the court if the case has moved to discovery. That being said, it sounds to me like your family has gone through some significant hardship over the last few years, which has made it hard for you to stay up to date with your bills. And this totally happens. And I'm really sorry to hear that you had to deal with that NICU stay. You know, having a baby in the NICU is a stressful and very sad circumstance in many cases. So I'm sorry that you and your family had to go through that. That being said, the reason I bring this up is because, like, if you have significant reason and real reason as to why you fell behind on your payments, it might be a good opportunity for you to share that information with the creditor that's suing you. You know, again, debt collectors can seem really scary at times, but they're humans too, and they will hear you out. So if you can just explain, like, and maybe even like bring documentation as to why you fell behind on your payments, and like show your financial hardship and prove it, there's a good chance that you could try to reach a settlement before you have your actual court date. So that, I think that's a good route to take. But yeah, if you have any other sort of like documentation or proof that you shouldn't be held responsible for the debt, whatever it is, now is your chance during discovery to submit that to the court in most states. All right, we've got several more live questions. Let's see. All right, sorry for that moment of silence, everybody. Just trying to figure out which questions to prioritize here. All right, let's see. We've got a question from Jimmy. It says, how should I handle a plaintiff's request for discovery? Do I answer all their questions? Should I do the same thing back to them? I used Solo to file the answer and file a motion to compel arbitration. Should I wait for the judge? I'm in Arizona. All right, so if you're in Arizona, Jimmy, I would recommend going to the Consumer Warriors YouTube channel. Consumer Warrior is an attorney named John Skiba, who's based in Arizona. He gives a lot of educational resources and information on his YouTube channel, and a lot of it would be like specific to Arizona since that's where he is licensed to practice. You can also check out his website. I think he has resources on his blog. Again, his YouTube is called Consumer Warrior, and that might give you some good resources to help you understand how to respond to a request for discovery. If they've asked you questions, like, you definitely want to respond to their request. If they've like sent in a request for admissions, you'll definitely need to respond. If you ignore it, there's a good chance that the case will end in a judgment and not in your favor. So definitely be sure to respond. I'm glad that you were able to file your answer already. But again, like filing your answer is only the first step in a lawsuit. It's going to block that default judgment, but it's only going to be the first step to trying to find a resolution. In some cases, the case might get dismissed, but in many cases, the case will move forward. And that's why I was saying earlier, at Solo, we see that usually best case scenario is to try to settle the debt before the court date. And again, we have tools like Solo Settle that can help you respond to the lawsuit, but also send an offer to try to negotiate and settle the case outside of court before your court date. Our platform has seen debts settle in as little as 2 days. I think the average amount for settlement time is about 14 days on our platform. So if you're trying to settle and just move forward with resolving this debt, head on over to solosuit.com/solo settle. It's a really great tool to help you kind of get in that process. But if they have sent you a request for discovery, you definitely want to respond. Do not ignore it. And again, John Skiba, Consumer Warrior, he has some great resources that might help you know what's best to do specifically in Arizona. All right, we've got a question from John S. It says, I offered, and by the way, everyone, since we are, over time, I think this will probably be the last question that I respond to tonight. But if you have any other questions and you're still watching live, again, I just want to thank you so much for tuning in. And I want to say that you can contact us at support@solosuit.com. You can also call in to the Debt Hotline at 801-613-8181. And we will do our best to respond and point you in the right direction and give you the resources you need to defend yourself in court, but also to settle your debt and resolve it for good. So here's my last question of the night. It's from John. It says, I offered 35% of the total debt amount and they came back with 75% of the total amount. What should I offer next? Okay, John, so this is really great progress. I'm excited to hear that you got a response, and 75% is actually not that bad. Obviously, there's a huge range of settlement percentages that could happen in a case like yours, but 75% is really not that bad. You could come back with somewhere closer to 50%, see what they say, see if they could go down any further. You could explain that you have financial hardship or that you have certain life circumstances that made it hard for you to keep up with the payments. But yeah, if they're offering you 75% at this point, that might be actually a really good offer for you to accept. Obviously, you're going to have to review your finances, figure out if that's something that you can realistically afford. But just know that 75% is not that bad of a place to be. But I think you could definitely come back maybe somewhere closer to 50% and see if you can get them to budge any more. And if you have any sort of proof that you're experiencing financial hardship or that you simply can't afford the 75% that they're requesting, just communicate that with them, show them, and they should work with you. All right, everybody. Thanks so much for watching tonight. Again, I just want to share that we are hosting the Independence Day giveaway at Solo. And I'm just going to share a link to that one more time for anyone who is watching. You can go and sign up and enter the giveaway. Let's see. All right, I just shared the giveaway in the chat. You can enter every day until the end of the month for a chance to win $4,700 to pay off your debt. This is just a way that we wanted to show how much we care about our users. And, we really genuinely want to help people settle and resolve their debts. And so that's why we're working hard to build tools and solutions to help it make it easier for people to do so. And again, you can enter every single day. So click on the link that I just shared, solosuit.com/giveaway to go and enter. And then lastly, I did want to drop a little resource in the chat that pertains to the topic of tonight's live stream. We have a blog post on our website called How to Prepare for Court. So for anyone who has filed their answer and has like a court case coming up, this is a really good resource for you to know how to prepare for court. Included in the blog post, there's a video interview with a real attorney licensed to practice in California. And she shares tips and tricks on how to prepare for court if you do have a court hearing scheduled. And that's obviously a very common thing that will happen after you have filed your answer. So again, with all that being said, I just want to say thanks everybody for watching. Solo is rooting for you. We know that you can find a resolution to your case. Settlement may be, in most cases, the best outcome. But please reach out to us at support@solosuit.com or call into the Debt Hotline at 801-613-8181. We'll respond to your questions live twice every single week in our Debt Hotline podcast. And yeah, good luck everybody out there. And thanks so much for